I mean, I get the idea. It's a little bit of a conundrum, but if in fact you're right and that there is a fraudulent joinder, doesn't that just get read back in to the situation that existed at final judgment?
I don't think so. I mean, the Fifth Circuit's decision, with all due respect to them, they don't have a time machine. They can't go back and change.
No, but that's
what
the Caterpillar situation. You would just concede at that point. I mean, you would cure it, right? So fine. You know, Whole Foods was fraudulently joined, and we could continue to go on. But because you win in this situation, you would cure it.
No, but I mean, that would be Newman Green. In Caterpillar, the non-diverse defendant was already out of the case before final judgment was entered.
I understand, but the idea is that some jurisdictional defects can be cured by the time we get to final judgment. And Caterpillar, the cure was the person was actually settled out of the case permanently.
Yeah.
And so we don't worry about the fact that previously in the case there might have been a jurisdictional problem. What I'm saying is that same solution would seem to me to be the answer to the conundrum that you're talking about with Justice Kagan.
I disagree, Justice Jackson. I think either a party is in a case or isn't in a case in the district court.
No, I understand, and that creates the defect, and the question is, can that be cured? And in the situation you're positing, maybe. Because by the time you get to final judgment, then perhaps the plaintiff would agree to the defect in this way, or agree to the cure, and then we'd be fine.
So, but I understood. I mean, what I was saying is that if the Fifth Circuit had decided on appeal that Whole Foods was correctly dismissed, that the fraudulent joinder ruling was correct, under the view you're positing where Whole Foods was a party all along, there still wouldn't have been jurisdiction to enter final judgment because Whole Foods wouldn't have been a party until it was affirmed on appeal that their dismissal was correct.
Ms. Harrington.